covering compensation for amputation injuries. If you suffered severe injuries in a maritime accident that required amputation, you have the right to receive compensation. Limb loss is a financial costly loss. Patients face treatment costs for the rest of their lives. Under maritime law, you have several avenues for recovering damage, especially if negligence is involved. Since maritime law is different from law or land, it is vital to contact an experienced maritime amputation injury attorney as soon as possible to help you achieve the best possible results for your case. Understanding maritime injuries. In 2013, the Centers for Disease Control Police report examining fatal maritime injuries from 2023 till 2010. It found that those working in offshore oil and gas industry are 7 times more likely to die vessel or working in the maritime industry. Dangerous conditions are present and vessel owner and employers must take appropriate measures to protect them. Those in charge of vessel are responsible for maritime injuries. Vessel owners and employers must ensure they provide safety training for workers and ensure that their ships and rigs are seaworthy. This is true even in the face of natural disasters and heavy weather like hurricanes and tropical storms. Rough seas are no excuse for a vessel capsizing or sinking. If the owner knew of the storm and failed to evacuate crew or take measures to avoid it. Vessel owners and employers are responsible for making sure the following exist: safety training, vessel maintains, safety equipment, safe work practice. Offshore workers who sustain maritime injuries have a chance for recovery through the dohsa, also known as the Maritime Act of 1920, that protects U.S. citizens working offshore. It enables injured workers to hold vessel owners accountable for failing to protect their safety. Essentially, the Jones Act provides similar protections to offshore workers that their onshore counterparts enjoy. It requires employers and vessel owners to be responsible and holds them accountable for negligence. Jones Act settlements include compensation for the following: lost wages, pain and suffering, loss of earning capacity, medical bills. Following a serious accident, injured seamen may face a host of costs. Those do not only have an immediate impact but can affect them for years. In almost all cases, the immediate effects are obvious in the inability to work, sleep pills, and the pain and suffering associated with the injury or illness. Even the future costs of rehabilitation are often well known. However, it is not always easy to see what the future cost of an injury will be. In some cases, the individual may require lifelong medical attention or may eventually pass away from the side effects. For this reason, it is crucial that the injured and their family recover this damage for the injury under maritime law. Consider these costs that could result from a maritime injury or death of a seaman: hospitalization, in-home care, emotional and financial counseling, long-term rehabilitation, lost wage and earning capacity, vocational rehabilitation. After an accident, one of the most important things you can do is to ensure all of your needs are met medically, legally, emotionally, and financially. However, this can be difficult. Therefore, it is important to keep in mind a few issues that could be compromised. First, remember you have the legal right to select your doctor. Never feel obligated to choose the doctor's office or attending physicians your business or insurance company may be pushing on you. Often you will need to see the recommended doctor for an evaluation, which is the extent of your obligation. Who you choose for treatment is up to you and should not be threatened by any employer or adjuster you may be working with in regards to your case. Second, you are entitled to medical treatment. The provisions of medical benefits is protected under the Jones Act, so injured maritime workers need not worry about being compensated for recovery. This is true regardless of who may be at fault for the accident. Furthermore, the Jones Act protects injured seamen who may be given differing opinions by doctors. This means that if one doctor recommends treatment while another claims it is not necessary, the disagreement will be resolved in favor of treatment. Unfortunately, many injured seamen have not been heard for the first time. However, your pre-existing condition is aggravated, then employers will be obligated to ensure that adequate coverage is provided. All that will be needed is an evidentiary statement made by your doctor on your behalf. In the other, you are entitled to medical benefits and financial maintenance payments, whether or not your signed paperwork approved for by an insurance adjuster. In fact, it is in your best interest to be cautious of any documents brought to you by an insurance adjuster. These often don't have your safety and well-being as a priority. As such, you should be hesitant to sign any paperwork under the condition that medical benefits and or maintenance payments rely on a signature. Third, you are not required to give a recorded statement after any sort of accident and or injury. Of course, reporting the incident as quickly as possible is a crucial step of the process. However, attention must be paid to the fact that many accidents can affect the memory and mental functioning of an injured person. Therefore, it is unwise to record a statement of events that may later need to be adjusted, a process that can prove to be quite difficult. That's all from me. Thank you for watching. Don't forget to like, comment, share, and subscribe. See you.